SJC-12493, Commonwealth v. Randall D. Tremblay.
Mr. Levin, good morning.
Good morning, Mr. Chief Justice, and may it please the Court, Patrick Levin on behalf of Randall Tremblay. We're here this morning on further appellate review of an interlocutory appeal from the suppression of statements. And if the Court will bear with me for just a moment, I'd like to begin with a few fundamental black-letter principles, first for the trial judge and second for this Court, that I know the Court has heard them before, but I think it's important to bear them in mind as we approach this case. First, in the trial court, that it's the Commonwealth's burden to prove a valid waiver of the Miranda rights beyond a reasonable doubt, by which we mean the highest certainty possible in matters related to human affairs. That trial judges are instructed to indulge every reasonable presumption against a waiver of fundamental rights, including the right to remain silent. That judges are instructed and police are instructed to exercise special caution above and beyond that standard when there's an indication that the defendant may be under the influence of drugs or alcohol. That the failure to record a waiver itself is a significant factor that weighs against the Commonwealth being able to carry that burden. And second, in this court, that a judge's credibility determinations about the witnesses that he hears testify before him are not open to re-examination, that his subsidiary findings are accepted absent clear error, that his ultimate findings are open to re-examination, as are his legal conclusions, but that his ultimate conclusion as to waiver is still entitled to substantial deference from this court. And I would suggest that the court has to read a record on one of these appeals in a light favorable to the judge's ultimate conclusion. That's what we mean by deference to the motion judge. And in this case, we're here today because the appeals court didn't do that. And the reason they didn't is that there were two interrogations in this case. The first one was not recorded, and the second one was.
That's really important. I don't want to oversimplify this argument because it is complicated. But Judge Salinger, in deciding whether or not the defendant's intoxicated enough such that the government couldn't prove beyond a reasonable doubt waiver, takes into account a credibility determination as to the defendant's intoxication level at the first interview. And the appeals court doesn't see that first interview.
That's right. And so that the operative waiver in this case is not recorded. And the fact that we can see the defendant on tape beginning an hour and a half after that operative waiver, that doesn't permit a de novo review of what happened during that untaped waiver.
But let me ask you, what did the judge find about that first waiver? I mean, because he didn't see it either.
He found that the defendant was intoxicated, that the police did not exercise the special caution that this court has instructed them to exercise to make sure that the defendant didn't unknowingly waive his rights while under the influence.
Is that enough on finding of waiver voluntariness and knowing intelligent voluntary and a voluntariness issue? Is it enough to just say you're intoxicated?
Well, he found that the defendant was heavily intoxicated and that he wasn't convinced beyond a reasonable doubt that the waiver was knowing and intelligent. And I would say that between the evidence of the defendant's consumption of alcohol and the failure to record the waiver and the judge's determination that the officers at the hearing were not telling him the truth, that between those three factors...
I missed that factor, the one where the officers were not telling the truth, that finding?
The officers testified extensively that the defendant did not appear at all intoxicated.
And so the judge specifically found that was a lie?
he specifically found that the defendant appeared very intoxicated and that any reasonable person would have known that.
Do you think that's true with the second tape too?
Yeah, certainly at the outset of the second tape, it's definitely true. And obviously, the defendant is sobering up throughout the course of his interaction with the police that night.
I guess the difficulty is you watch, as I did, you watch the second tape, and he stumbles, and sits down. But he answers questions. He's very responsive. He doesn't seem out of it, I guess, for lack of a better word, at all in the second interview. And I know you're talking about the first, Mr. Levin, and he didn't get, I think, as you point out, he was more drunk to start. He didn't drink during his time in custody.
That's right.
So we know he was sober enough over that period of time.
And
But the difficulty, and I think what the appeals court focused on, was his capacities in the second interview, which I think as a trial judge, people have seen 100 times, and people usually are found to have waived their rights validly.
I think you're right that people usually are, and that's because the judge usually credits the police testimony.
No,
that-
no, I'm talking about watching the tape. So, I mean...
Well, certainly,
When
I mean,
you,
if the
when you
tape...
watch that, I know you're talking about the first one, but when you watch that tape for the first time, you're struck, or at least I was, by how responsive he was. I mean, I was concerned that he was intoxicated because he was stumbling, and certainly you get that from the Orange Line video.
Yes, absolutely.
But then once they get him in the seat, he's answering questions, he's responsive, he's appropriate. That's I guess the difficulty, probably where the appeals court focused on.
I think you're right that that's what the appeals court focused on, and I think that if the waiver at issue was at the waiver at the beginning of the second interrogation, that we would have a very different case here. That in fact, if this was the only interrogation that had occurred, and essentially the only really pertinent evidence at the hearing would be the videotape, then I think it would be appropriate for this court to take an independent look. And frankly, I think the motion judge probably might have reached a different conclusion.
Was there any argument regarding fruit of the poisonous tree or cat out of the bag with regard to these statements?
Yes, there was, and the judge analyzed it on that basis. It's really a sort of a separate analysis, right? And that's the way it was argued below and analyzed by the judge, is that the first question is whether the statements during the first interrogation are admissible, or whether the waiver has been proved beyond a reasonable doubt to be valid at the outset of the first interrogation. And then if not, then the statements during the first interrogation must be suppressed. And then the question becomes whether the recitation of the Miranda warnings at the outset of the second interrogation could cure that.
But yeah, we don't get there though if we say, as you suggest, that the first one wasn't interviewed, there's no de novo review, judge made a finding, we stopped there.
Yeah, and I think that's where this court does stop. And I just want to emphasize
Well,
that...
do we stop? And by the way, I had neglected to mention at the beginning that Justice Lank is sitting on these cases and is actually watching as we speak for the entire day, but I had neglected to do that, but I want to make sure that parties know that. Aren't we in a somewhat different, I mean, let's assume you're right. Let's assume we have a clearly erroneous standard. In exercising that review, are we not in a somewhat different position where we can actually see the second videotape? Is that not can we at least apply that in determining whether the judge was clearly erroneous in his finding as to whether or not during the first unrecorded interrogation he knowingly and voluntarily waived his Miranda rights?
So you're in a somewhat different position than if there were no recording at all. That's true. But I think it's really essential to this case, the fact that the question of the relationship between the witness credibility and the video evidence is not a one-way street. That the judge didn't watch the video and decide based on the video to discredit the police testimony, and that's as far as it went. That on the contrary, the judge's evaluation of the credibility of the witnesses affects the inferences that he reasonably can draw from the video recording. that if you look at a video this is the two recent Seventh Circuit cases that I provided as a supplemental citation last week, I think are, they're obviously not on point exactly, but they're instructive. That when you watch a video recording of a confession, that's not the end of the story. That you have to draw inferences about the reasons for the conduct and statements that you can see. And so the judge is in a position to draw those inferences based on his view of the credibility of the police witnesses. And the inference that he draws from the fact...
He's saying that the police underestimated or exaggerated his sobriety. That's his core credibility finding, right, Mr. Levin?
Yes, that's right.
All right, so then he has a hearing, the two police officers, did both testify or one?
3 police officers
Okay.
testified at the hearing.
Okay, so the police officers testify, and he looks at these witnesses, and they testify, and he says, based upon your testimony in front of me right now, and based upon what I see on the video, you're not telling the truth as to his sobriety. Aren't we in the same position as the judge to say, well, at least on the second video, maybe they were or maybe they weren't telling the truth about his sobriety based upon how he can answer questions, function, retrieve information, etc.
You're not in the same position as the motion judge to decide whether the police were telling the truth, because he's the one who saw them testify. And that's the fundamental point.
Well, the fundamental point, as I see it, and please correct me if I'm wrong, the fundamental point is whether or not the defendant was so intoxicated at the first interview such that the Commonwealth didn't prove beyond a reasonable doubt that he had waived Miranda. That's really the way I look at this. Was because the second interview, well, he is how he isn't the second interview, but that's the cat out of the bag.
That's right.
So really, what we're trying to figure out here is did the Commonwealth prove beyond a reasonable doubt waiver at the first interview that we can't see? Am I wrong in that analysis?
No, you're just right about that. And I want to sort of dip back into the record that's not on video for a moment, because the judge specifically says in his order, I credit the testimony to the extent that it's consistent with my findings. I heard the testimony and I saw these tapes, and I make the following findings based on the credible testimony and the reasonable inferences I draw from the evidence. And so there's testimony at the hearing that at 11 p.m., Mr. Tremblay and Mr. Doucette go to a liquor store, and they go in one after the other, and the clerk won't let them buy anything. And it's a reasonable inference that the reason they're not allowed to buy anything in the liquor store is because the clerk looks at them and says, you're too drunk, I'm not letting you buy any more alcohol. And then they do succeed in buying a 12-pack of beer, and you have the video on the platform at Back Bay. He's drinking, he's unsteady, he's clearly intoxicated, and he's carrying this plastic bag full of the rest of the 12-pack. Now, the judge credits police testimony that at the scene, Mr. Doucette seemed like he had been drinking and Ms. Finley did not, and they only found empties at the scene. So it's a reasonable inference at that point that Tremblay and Doucette, between them, are already so drunk at 11 that a liquor store clerk won't let them buy anything, and then, over the course of the next 3 hours, killed a 12-pack between them.
And wasn't there also evidence about his behavior at the scene?
Yeah, and he's acting erratic at the scene. I think that's safe to say. And this is what I'm getting at when I said at the outset that the idea behind deference to a motion judge is that you read the record, the entire record, and the totality of the circumstances in a favorable light to his ultimate conclusion.
So if we, and I think you can see this, if we were just looking at the second interview and the motion judge had made findings that he was unable to knowingly and intelligently waive because of his intoxication, you'd have a problem, wouldn't you?
It would be a much harder case for me.
Even you
But
would-
I mean, I don't think we would be here. I think he would have had his trial by now.
Can I turn to one issue? I know we're sort of out of time, but with regard to the seizure of the clothing,
Yes.
was there a restraining order at the time of her death?
Yeah, I think it's an exhibit.
So why would it not be appropriate to arrest him for apparent violation of the restraining order, and then the blood, arguably to the extent that it might be hers, would be evidence of his violation of the restraining order?
Well, Your Honor, what I would say about that is that in any event, the motion judge was right that they should have sought a warrant at the earliest practicable time before they retained the evidence and ran DNA tests on it.
If it was a search incident to arrest on the restraining order, for which they had probable cause, they would need to get, why would you need to get a warrant to hold on to it to test it?
Your Honor, this hasn't been extensively briefed, obviously, but what I would say is that by analogy to the court's cell phone cases, that the seizure is appropriate incident to arrest, but that the DNA analysis is a separate search requiring a warrant, and that this court's opinion in Arzola is incomplete. That under the Supreme Court's holdings in Jones and Jardines, that the retention of the clothing and the testing of it is a more substantial interference with the defendant's property rights in those items, and so constitutes a second search, and that the Arzola opinion only analyzes that question as a matter of reasonable expectations of privacy.
Okay, but that's before us. You
It
agree?
is.
Okay, so we'll,
It's in my brief.
I know it's briefed, but maybe not as extensively as you would like, but you're pretty exhaustive in general. Thank you.
Thank you very much, Your Honor.
He said exhaustive, not exhausting.
Exhaustive, yes. Ms. Smith?
Yes.
Equally exhaustive.
But hopefully not
never
exhausting either.
exhausting, yes.
Good morning, Your Honors, and may it please the Court. Janice Smith, on behalf of the Commonwealth, we're asking this Court to reverse the motion judge's allowances of both motions to suppress the statements and the results of the forensic testing. I'd like to, before I begin, I would like to point this out. The judge never made any finding, explicit or implicit, that these officers were lying in their testimony, and I think that needs to be made clear.
I have no idea what the court credits their testimony to the extent they are consistent with explicit findings of fact made below. I really don't know what that means.
I think that's somewhat of a way to say what I say is the only thing that I find, but he certainly doesn't discredit specifically anything else. So he never makes a finding, I didn't believe these officers were telling the truth, I didn't believe these officers were lying. The only finding that he makes is that Sergeant Stratton should have known that the defendant was drinking. That certainly doesn't say that he believes that Sergeant Detective Stratton was lying. So I'd like to at least set the record straight on that.
And can you address the relationship between you should have known somebody was drinking or somebody was drunk versus what it means to be not able to voluntarily, knowing and intelligently waive something or render a voluntary statement?
The two inquiries are entirely different. Somebody can be intoxicated or drunk and have consumed an excessive amount of alcohol and still be able to validly waive their Miranda rights. It is an objective, it's the police, we let the police use the outward indicia of what the defendant is doing, his behavior, his statements, to inform whether or not those police officers believe that the defendant is too intoxicated to validly waive Miranda. So the real question here isn't, was the defendant drunk? The real question is, did intoxication prevent the defendant from being able to validly waive his Miranda rights? And the judge's findings with respect to the second interview, and I think this is going to get into a lot of what my brother's argument were, informs the validity of the waiver in the first.
So is there a cat out of the bag issue here where we give him deference for the first interview, we look de novo for the second interview, you lose the first one, you've got a cat out of the bag problem for the second one?
Let me address that with 2
To follow
points.
that, good luck to you.
This is actually what we struggled with in preparing for this argument. Because this court can look at the defendant's behavior in the second interview to inform the validity of the waiver in the first. And that's relevant because it takes the cat out of the bag and makes it irrelevant.
Even with the hour-and-a-half passage of time?
Yes, I think so. And let me give the court a couple of reasons why I think that. The defendant's clarity with respect to what happened during the first interview is evident during the beginning portions of the second interview. At the beginning of the second interview, he recounts with great detail, essentially, what happened before. And I'll give the court a couple of specifics. He knows exactly why he's giving a second statement, because the recording had malfunctioned. He even makes a quip to one of the detectives when he says he's going to put his phone down to record it. Yeah, that's what you said last time. So he has a great awareness of what happened during that first interview. He acknowledges that he was given the Miranda warnings before. He acknowledges that he initialed, signed, and dated each one of those. And he then gives a substantially similar, in all material respects, same statement that he gave before. If he had that, if his will was so overborne and overtaken by alcohol during that first statement, he never would have been able to recount what he did in the second. So this court can look at the video to inform the validity of the waiver of the first. That was the first point I wanted to make with respect to Your Honor's question. The second is with respect to cat out of the bag. This court's decision in Prater, which was affirmed in Thomas in 2014, talks about cat out of the bag is coercive external forces and primarily a sense of futility that the defendant had already incriminated himself. We don't have either of those situations here. There is no coercion, and I think that's evident by the videotape. It's a conversational interview. Sergeant Detective Stratton isn't employing any trickery or any deception. And there really is no sense of futility. The defendant doesn't have that demeanor of, well, this is all over. So I'm not sure cat out of the bag truly applies, but I don't think this court needs to get there because the validity of that second waiver the first waiver, is informed by what happened in the second. And I think that's really the biggest piece of it. And this court's de novo review of the second will clearly show that this defendant was not too intoxicated.
To that point, could you talk a little bit about what we do when there's both documentary and testimonial evidence? At what point do we stop giving deference to what the motion judge did?
Certainly. With respect to the video, this court looks at that de novo, and the contents and significance.
Doesn't it all come together? Don't you look at the totality? And if you've got both, doesn't the motion judge get deference?
No, not necessarily, because at least not in this case. Yes, the court looks at the video de novo, the court looks at the testimony and the findings of fact with deference to credibility findings that were made by the court. I think that's clear in this court's decisions in Novo and in Clark and in Newsom. I think that's all relatively clear. But in this case, the findings of fact actually don't weigh against the ultimate, don't go against the Commonwealth's position that the defendant was not too intoxicated to validly waive Miranda. The judge makes no findings in that first statement that the defendant was stumbling, that he was slurring, that he was in any way falling down. Those would be credibility findings that the court would then be able to say, well, maybe there's a distinction. That's just not what we have here. This court can also go back and look at the defendant's behavior at the scene and the judge's factual findings with respect to that. Yes, he says that the defendant is seen mumbling and talking to himself. He also finds that the defendant was responsive to officers and even reluctant to give his name because he doesn't want to be run. This defendant knows he has an active restraining order, and he knows he's in a place he shouldn't be, and he has the presence of mind and the awareness to not want to give up that self-incrimination. This defendant knows what he is doing and is aware of the gravamen of the situation in front of him.
Well, so that's a really compelling argument, and I mean that. I'm not being caustic upon it. But what we're doing is, and you make a great point about cat out of the bag. But what we're doing ultimately is determining what the first interview. It's all about the first interview that we can't see.
Yeah.
And the judge hears from 3 witnesses, and makes credibility determinations about the first interview, and then hears a argument like you just made and the defendant makes, and then the judge has to decide whether or not in his bones he believes, as the trier of fact, that the government has proven to a moral certainty that the waiver was made knowingly, intelligently, and voluntarily. So it's hard for us to go back to that closing argument moment and decide whether that burden of proof has been satisfied if we didn't get to see the three witnesses or have to make the credibility determinations as it relates to the first interview.
Well, in that scenario, and again, this is such a unique situation with the video, and I know I keep coming back to that. I don't mean to sound like a broken record. Where this court is able to use the video to make that determination is because the judge's specific finding of fact that the defendant was too intoxicated is based on the video, and that's at page 8 of the Commonwealth's record appendix. And in the interest of not misquoting the motion judge finds, since it is apparent that Tremblay was quite intoxicated throughout the second police interrogation, the court infers and therefore finds that he was even more drunk during the first interview. So his real basis, his ultimate conclusion that the defendant was too drunk is solely based on that video.
Well, that's not entirely fair. I mean, wasn't he also focused on the fact that this guy doesn't seem to understand that we're talking about a murder? He keeps complaining about the warrants and says, can I go home now? And I mean, he did focus on the fact that this guy seemed pretty clueless as to the consequence of what he was saying. That's another factor the judge considered.
The judge did consider that, and I would suggest that the judge is wrong and that the judge's conclusion is erroneous, again, based on the video where the defendant says at least 10 or 11 times, admitted that he screws up, admits that he says, I'm going to jail anyway, I'm jail-bound regardless, you guys are going to charge me, do what you want to do. These are all the defendant's own statements. He is aware of the gravity of the situation, and he does know that he has incriminated himself, and I think that's clear.
But didn't the police also tell him, essentially, we're not going to hold you for this, we're going to hold you because of the warrant? And that's what his big complaint is. He's saying, wait a minute, let me go, this is a straight warrant.
Well, he says that he knows the difference between the straight warrant and a default warrant. The police never say that they're not, they're holding him on the warrant. They never say that they're not.
That's what he really is focused on, the fact that they're holding him on the straight warrant. And the police are using that for the custody decision, not what he admitted to.
And they say, you're holding me on a warrant, and they say that's right. And Sergeant Detective Stratton says, I believe it's towards the end of the video, I don't have the exact timestamp on it, I'll go back and I'll check it out. Or he actually says it at the beginning and at the end. But he was being held on a warrant. There was an outstanding warrant. There is no dispute that there was an outstanding warrant.
It wasn't without reason that he was annoyed that they were making a custody decision based upon the warrant.
No, it's not that he was without reason to be annoyed, but it certainly doesn't show that he didn't understand that he had incriminated himself, and that's the more proper focus of the inquiry, is does he know that he incriminated himself? And the police are not required to give the defendant a roadmap. They're not required to say, this is the, oh, you just made a statement that was against your self-interest. They're not required to do that.
Was she strangled?
There was evidence of blunt force trauma. That I don't recall any evidence of strangulation. It was an incredibly bloody scene, and there was a great deal. There were pools of blood, and there was bruising. She had been deceased for a bit before the police got there.
With respect to the conduct that he admitted to, was it less extensive than that which you allege he did?
Absolutely, Your Honor. That's an excellent point. He actually minimizes his own conduct, which again goes to his state of mind and his ability to rationally decide to give a statement. He says, I only slapped her. He doesn't say that he hit her with closed fists. He says, I've never done this before. He's minimizing his own conduct. He says that she invited me in, which shows knowledge of the restraining order. He admits to having the restraining order. But the fact that he knows enough to minimize punching as opposed to using a slap does show that his awareness and his self-interest, which speaks to voluntariness and intelligence, and that this is the product of free will.
Now, you carefully referred to the second, or the videotape as, in, I think you said, informing the validity of the waiver at the first interview.
Yes.
And I'm trying to figure out what that means. That could mean that you agree with the appeals court that we should consider it de novo as to whether or not there was a waiver at the first interview, or you could say, well, no, it's clearly erroneous standard with regard to the first interview, but we can look at the second video and that will inform us as to whether or not it was clearly erroneous. Which one?
I think the second is actually the more appropriate standard under our law, because you are looking at this in a totality of the circumstances, and the totality of the circumstances is testimonial and documentary evidence, including the videos at the MBTA station and at Clarendon Liquors, and the video, which is part of this court's review in that totality, can determine and should determine that the defendant was able to validly waive his Miranda in the first interview. The judge used the second video to take a look back in time to determine what happened in the first. This court can do the exact same thing.
Okay, so you're saying, well, the appeals court was off in terms of saying the whole thing is de novo, but they came to the correct conclusion because it was clearly erroneous based on a de novo examination of the recorded interrogation.
I think what the appeals court did was they made a determination, and I think a correct one, that the judge's ultimate conclusion and ultimate findings of intoxication were solely based on the video. Okay, and because of that, they looked at all of this de novo. I think this court has to look at all of the evidence in its totality, but the video review, which is what formed the basis of the motion judge's real conclusion of over-intoxication or too intoxicated, was that second interview.
But I assume there was, I've seen the recorded interview. I've not looked at the transcript of the hearing. Was there testimony as to what happened during the first?
Yes, there was.
So he did hear testimony as to, here's what happened with regard to my giving Miranda, and I guess they offered that. Again, so there was testimony with regard to what happened at the first.
And the judge specifically finds that Miranda was given. That the Sergeant Detective Stratton provided Miranda warning. So there's no finding that it didn't happen. That actually, it's the contrary.
Can I ask you a question?
Of course.
So it sounds like what you're saying is all the motion judge needed was the video, and you make that decision based on the video, and so there would have been no need for any other testimony or anything like that. Once you have a video of the interview, heck, it can go straight up. It can go straight up on appeal because we can figure it out just as easily as the motion judge.
I think this court in novo, in allowing a de novo, interesting choice of case names, allowing the recordings to be reviewed de novo, yes, that otherwise on a videotape statement, a judge's findings would be insulated from appellate review, and that can't be the standard.
But I guess my point is, here there was other evidence. It wasn't just the video.
Yes.
And so it sounds like you're saying, but that doesn't really matter.
I think in this particular case, it doesn't matter because this court can look at the factual findings as found. We're not asking you to find anything else. Look at the factual findings as found in conjunction with the de novo review of the video and make the determination that the judge's legal conclusions were clearly erroneous.
Well, I think saying something simpler than that, whether it's right or wrong, I don't know. You're saying that this particular judge, in this particular motion to suppress, decided that the linchpin of his decision was the second interview.
That's correct. That's exactly correct. You said it much more eloquently than I could have, Your Honor. That's exactly right. And because of that, this court is then able to review his determination and find that it is clearly erroneous. If the court has...
Just one last question, at least
Sure.
for me. I didn't see anything in the recorded interview that involved an inquiry by the police to him as to tell me how much you've drunk before we spoke today. Did they explore with him?
No.
So that's not there.
No, but what this court can do is look at the timeline of events and the evidence, including what the factual findings are, to make a determination. And what we do know is that at 5:30 or 6 o'clock, the defendant wakes up after having been passed out for 12 hours. He has a beer. That is what he says. He has a quick beer. That's his statement. At 7:30 or 8, he takes the 32 bus back into Back Bay. Again, that's his statement. And what a recollection of detail, the bus number that he took. He's then seen on the video, which is one of the exhibits at the motion, holding a paper bag and drinking something. I think we can infer that it was alcohol, but we certainly don't know that.
Well, he's rubber-legged, too.
There's a bit of stumbling, but he's certainly able to walk, and there's no findings otherwise before that. The police are called, and he has a beer just before the police are called. So really what the evidence shows is that he had 3, maybe 4 beers between 5:30 or 6 o'clock at night and 2 o'clock in the morning, which is when the police called. There's absolutely no record evidence that he had anything to drink between 2 o'clock and 3:40, which is when he's arrested, 4:30 at the first statement, 5:50 at the second statement. And that is in line with the factual findings. Sergeant Detective Stratton testified that he had some beers. There's no quantity, and again, we can't get caught up in that he drank. We have to be able to review whether or not any intoxication invalidated Miranda. And if the court has no further questions, I'll rest on the brief. Thank you, Your Honors.
All right.